Okay, tell me when I'm ready. When you're ready.
We're good.
Okay. Good evening. This is Angela Jameson, Chair of the Inland Wetlands Commission, calling to order the special meeting of the New Canaan Inland Wetlands Commission on Monday, September the 15th, 2025 at 6:01 p.m. So please could the secretary take the roll?
Sure. Angela Jameson.
Present.
Sandy Redden, I'm here. Beth Bernali.
Absent.
Not yet. She may be coming a little late.
Beth Sanford.
Nope, not here. She may be a little late too.
Dan Stepanek.
Here.
Phil Williams.
No, he's absent.
Priscilla Wilkie. Priscilla, yeah? Yep. I'm sorry that you guys are tiny. Peter and I are very large on my screen. Don Mastronardi.
No, he's absent.
Katie Owsley.
She's absent.
Adam Ramirez.
Present.
Good. Thank you very much. Well, the special meeting is to have some training from Town Attorney Pete Gelderman on some legal questions pertaining either to the CT general statutes or to the town's inland wetlands regulation and general way of conducting ourselves when we're doing official business. So thank you very much, Pete, for agreeing to do this. And we provided a list of questions ahead of time. I hope that we'll be able to get through as many of these as possible. And I suggest if commission members have questions as Pete is speaking, they raise their hands and we'll find a suitable moment to answer that question. But over to you, Pete.
Thank you, Angela. For the record, my name is Pete Gelderman. I'm with the firm of Bircham Moses. I operate our Tennessee office. Just kidding. I'm in Tennessee, but we don't have an office here. So anyway, I have the list that Kathleen sent over of topics. So I assume everybody has the same list, and I would just propose to go in order down the list. And as Angela said, if anybody has any questions while I'm going through it, you know, I think it's better if you ask them as we're going through rather than waiting till the end, because you'll forget the question or whatever. I just think it makes more sense to ask as we go. So the first issue deals with interventions. There's a state statute 22A-19, which permits any person to file a verified petition for intervention in any administrative matter. So that means that the petition has to be a sworn statement. There has to be an oath either taken by a notary or an attorney or someone, a judge, whoever's capable of taking someone's oath, because it's got to be a certified or a verified petition. And the petition needs to allege facts that establish that the activity that's being proposed is reasonably likely to unreasonably pollute the public trust in the air, water, or other natural resources of the state of Connecticut. Now, typically, since you're the wetland agency, you are going to be dealing with alleged unreasonable pollution if it deals with wetlands and watercourses. So there's an old case called the Nazardo case where someone filed a petition to argue that a specific activity was going to unreasonably pollute the wetlands, but it was filed in a traffic authority administrative case. And the court said that the traffic authority or the state traffic commission has no jurisdiction over that type of stuff. So it wasn't, pollution to water courses or wetlands. So they weren't the proper, that petition was improper. So that means that if and the petition has to allege specific facts. It can't just say, I swear that, under oath that I think this activity is going to unreasonably pollute the air, water, and other natural resources. That's not enough. You've got to allege in that petition for intervention what the facts that you're alleging are. And the reason people file petitions for intervention is it makes them a party to the proceeding, a party to the administrative proceeding. And that may be important for somebody who is not statutorily aggrieved. Let's say you have a matter that is before you, and someone who is not in a butter or doesn't live close enough to the site where the activity is taking place, they want to be a party for purposes of being able to be involved in an appeal to court down the road. They can file an intervention petition and would be a party to the proceeding before you, and therefore have the ability, if they needed to or wanted to down the road, to take an appeal. Sometimes neighbors, abutters, file petitions for intervention. I think that's, they can do it, but it's kind of unnecessary because they'd be able to be parties to any appeal anyway, since they're abutters. But when a petition for intervention is submitted to the commission, it's accepted. And then at the end of the public hearing process, the commission will determine whether or not the petitioner met their burden to prove that there's unreasonable pollution, in your case, to the water body or wetland, a water course or a wetland. And you'll make a separate finding at the end of your public hearing with respect to the intervention. So you'll vote on the application, you'll vote on whether the intervener met their burden of establishing unreasonable pollution. So usually you'll take 2 votes when there's an intervention involved. So as parties to the procedure before the Wetlands Agency, that means that they get copies of everything, just like an applicant would if there's opposition. They are treated like a party to the proceeding. So the applicant always gets the last word in a public hearing, but interveners also get they get more leeway than, say, just a member of the public would get. When you have a public hearing and someone gets up and speaks, maybe it's a meeting that you've limited the time to speak to 5 minutes, which you can do to the public, but not to the applicant, and then not to the intervener because they have party status. So they'd be able to present as much or as they wanted to without worrying about being cut off. And also, they always get a chance to rebut, although the applicant gets the last word. So
I have Angela Jameson here. A question. So we have to have 2 determinations, one on the application itself, whether to grant or deny it, but another on whether the interveners have satisfactorily proven what they're alleging. Now, which way round would we typically do this? Would we vote first on the intervention and then on the application, or the other way around?
The other way around. Typically, you vote on the application first.
Okay.
If a application you deem has no adverse impact on a wetland or water course, then it's almost certain that the intervener hasn't met their burden with respect to unreasonable pollution. But remember, wetland agencies typically are not, you've heard this before, little, EPAs or DEEPs. You're limited to wetlands and water courses. And so, they may prove that the air is going to be polluted, for example. But that's not something that's within your jurisdiction. So you wouldn't have to make a determination with respect to that kind of allegation. So their allegation is going to be limited to unreasonable pollution to waterways, not Long Island Sound, not tidal wetlands, but inland wetlands and water courses that are within the town. So, but that's kind of a long way of saying typically if there's no adverse impact, then the interveners probably haven't met their burden.
Thank you.
So you'd have a separate vote. And I'm just gonna, as I'm going down the bullet points here, it leads nicely into the public hearing aspect of it. The general statutes say that the wetland agency shall not hold a public hearing unless one of three circumstances exist. So the default is no public hearings. But you will hold a public hearing if a petition is filed. I think it's about 20 people file a petition asking the wetland agency to hold a public hearing. It's in the public interest. You determine it's in the public interest to hold a public hearing. Or third, there may be an adverse impact to wetlands and water courses, and then you would hold a public hearing. So the question that begs the question, well, how do we decide if it may have an adverse impact or not? And typically it's, that because evidence hasn't really been produced yet, because there hasn't been a presentation typically yet. So you make a judgment based on the activity and how close it is to the wetlands and whether it's in the wetlands. If there's activity within a wetland, that may have an adverse impact virtually all the time. If it's in an upland review area, then you're going to make a determination, based on the activity and how close it is to the wetland and what the likelihood is. And you're essentially relying there on probably Kathleen's input a little bit, and your own observation and your own determination of whether or not you think the activity may have an adverse impact. So it's, even though you haven't received a whole lot of information yet, you've gotten the application, you've received, plans, and you'd look at those and sort of make a determination using your own best judgment and the help of Kathleen, whether that activity could possibly, and not even likely, but may have an adverse impact on wetlands and water courses. When you get into making your decision on the permit application, then it becomes a likelihood scenario as opposed to just may. So that's when you would then hold a public hearing. I would suggest that when in doubt, hold the public hearing. If no public hearing is held, you have 65 days from the date of receipt of the application to render a decision. And as you all probably know, the date of receipt just starts a clock. It's the wetland agency, the Wetland Commission does not have to hold a meeting to accept applications. You don't have to do that. All that happens is the next regularly scheduled meeting following the submission of the application. That starts the clock. So, and it's the next regularly scheduled meeting, whether you hold it or not, it's the next regularly scheduled meeting. So that begins a 65-day clock to make a decision if you don't hold a public hearing. If you do hold a public hearing, if you decide to hold a public hearing, then you're supposed to open the hearing again within 65 days from the date of receipt, same date. But now you're holding a public hearing. So you want to decide relatively quickly if you're going to hold a public hearing, because the clock starts either way on the first regular scheduled meeting after the receipt of the application in the office. Are people raising their hands here? It's hard to tell. Kathleen. Yep.
It's me, Kathy Holland. Just 2 points of clarification. I may have misheard this, but the one of the 3 ways in which to have a public hearing be required our regulations indicate a petition signed by at least 25 persons who reside in the town.
Yeah, it might be 25. I'd have to look at the statute. It's either 20 or 25, but that's
Okay,
in the
I just-
statute. I can check that.
Okay, I just wasn't sure if it had changed and we hadn't updated our regulations, but I
No.
believe it is still 25. And I think your advice on, when in doubt, um, to whether or not to hold a public hearing, but with the caveat I would suggest is that if you are going to be holding public hearings, that you're consistent in the decision in which you're going to be holding that public hearing, rather than picking and choosing, maybe not consistently. I think for our commission, the public hearings tend to be pretty readily vetted in our process, at least my experience previously.
Okay, yeah, no, that's fine. I mean, it's just the wording of the statute that says, there shall not be a public hearing unless one of those three things happens. And yes, it's important to be consistent, but you have to look at each application if you're making your decision based on the fact that there may be an adverse impact. So you're looking at that particular application to determine if there may be an adverse impact and then deciding to hold a public hearing or not after that. So, and remember when this isn't really, I don't think it's on here, but when an activity has a adverse impact, that doesn't necessarily mean you're going to deny it. That's not an automatic denial because something has an adverse impact. There is a weighing process involved, but that's when you get into whether or not there's a feasible and prudent alternative. So, and whenever there's a feasible and prudent alternative to an application, the application has to be denied in favor of that feasible and prudent alternative. So, and that usually happens when you've made a decision to hold a public hearing because there may be an adverse impact. As opposed to, say, a petition. There's no, in a petition signed by 25 people, there's no indication yet whether the activity is going to have an adverse impact. And an activity that you approve that doesn't have an adverse impact does not need a feasible and prudent alternative, because no adverse impact, no need for a feasible and prudent alternative.
So Angela Jameson again, for example, we have traditionally had a public hearing because we believe it to be in the public interest when there's something significant proposed in relation to Waveney Park in New Canaan. And I think we've been very consistent on that.
Yeah.
But we have used the public interest route, which I think is somewhat easier than determining from the get-go that there may be a significant impact on the wetlands.
Yep, it's certainly a legitimate, that's one of the three reasons. And particularly when you're dealing with municipal property or public property, that, it's pretty easy in those circumstances to make that determination. But even a private application may be in the public interest to hold a public hearing. So.
Peter, this is Dan.
Yes, Dan.
Petition have to be.
Can you put your mic on, Dan?
Just so it picks up.
Does the petition have to be signed by someone from that town, or can it be signed from someone from California or New York or any name on that petition?
You mean the
One of the
petition to hold a
25.
public hearing, or the verified, okay, the public hearing petition?
Yes.
No, it's 20 persons. I don't think the regs limit it to New Canaan.
Well, actually, the town regulations, Pete, say that there needs to be a petition signed by at least 25 persons who reside in the town of New Canaan.
And there you go. Then that's the regulation requires that. So it's 25 residents. Now, you can be a resident of New Canaan and not be there, that day. You could sign a petition if you're in California on a business trip. You can still sign a petition and send it back. Yeah, so 25 residents. And generally speaking, they're electors. It doesn't say that, but that's how you verify signatures, is by checking person signatures, checking their name on the list of voters. If a signature is not legible and nobody printed their name next to it and it's illegible, it usually doesn't count. Because if you can't read it, you can't verify who it is. But that's probably the least common public hearing route, petition signed by 25 people. That doesn't happen very often, but it can. So now on the bullet point, it says, how does the holding a public hearing impact the decision process? Well, it doesn't really impact the decision process per se. You are still making determinations on what the adverse impact is, if any. Then you weigh the impact against the person's right to develop their property. But if something is going to have a severe enough impact on wetlands and watercourses, the activity can certainly be denied. And if there's a feasible and prudent alternative, it has to be denied. The only difference between public hearing and not public hearing is the timeline. In the timeline, after you close the public hearing, which you have 65 days to hear, after you close it, you have 35 days to make a decision. Did I say 65 days? You have 65 to open it, 35 to hear it, 35 to decide it, just so I'm clear. And you can have 65 days of extensions. So but you deliberate the same way you would deliberate if you didn't hold a public hearing. Same facts, you're deliberating the facts, you're the finder of fact. Courts are supposed to defer to your judgment as long as it's exercised reasonably and there's no indication of bias or predetermination or fraud or something like that, which I'm sure there isn't ever. I mean, in the case of your commission, that's not going to be an issue. But in the absence of any of those things, a court is supposed to defer to your judgment. And unless unless for some reason, you've abused your discretion, which is, again, not normal, not usual, then the court is going to sustain your decision as long as it's been exercised fairly. And most importantly, it's supported by substantial evidence in the record. And substantial evidence means expert testimony or reports. So that's if there's substantial evidence from an expert, a wetland expert, soil scientist, sometimes an engineer, in the record that supports your decision, a court is generally going to uphold that. But if there's not sufficient evidence or substantial evidence, then a court might reverse your decision if they find that. So while I'm talking about that, you'll often have experts representing an applicant and experts maybe representing an opposition group or person. And you can have your own peer reviewer who you've hired to be an expert to give you an opinion. So your decision's going to be supported by one or more of those experts. You're going to find, and even if there's opposing evidence in the record, that doesn't mean, because there's going to be, you're looking at all the evidence and making a determination of what evidence you think is the stronger evidence. If there's a credibility issue, was one of the experts more credible than another expert? Did they seem to, know their stuff a little bit better? You're the board that gets to make those decisions as you look at all the evidence that's presented in the record. So now, and then you've got cross-examining and whether or not you can, if you think someone's not being truthful, well, you don't really have the right to cross-examine. You have the right to ask questions. You can ask questions as members of the commission, but you're not supposed to cross-examine a witness. And if you do, it can lead to a complaint that you were biased, because the public hearing's still open and you don't want to appear during the course of the public hearing to be adverse to a witness. At the end of the public hearing, when you're deliberating, you may say, I didn't think that person was particularly truthful. And if you come to that conclusion as a body, you may, either discount or disregard that evidence submitted by someone who you felt wasn't being truthful. But
can I ask you, Pete,
Sure,
what's
sure.
the difference between cross-examining and asking questions when you believe that perhaps the expert or the witness has contradicted him or herself?
Well, if they've contradicted themselves, you can ask for clarification and say you said this, and then later you said this.
Well, I think actually, let me rephrase that question. Where is that fine line between cross-examination and just asking a question?
Cross-examination is you watch television and you hear lawyers object and say he's badgering or she's badgering the witness. That's really not a valid objection, but be that as it may, if it appears that you're taking a position and asking questions in support of that position, you phrase them. For example, I've got an expert on there, and he says something about nitrogen not an issue with organisms, and you say, wait a minute, you're telling me that nitrogen's not an issue with soil and with oxygen or whatever. I'm just making up this stuff. That I don't think that's correct. I think you're wrong. It sounds like you're taking a position as opposed to him, and as opposed to saying to him, you mentioned nitrogen. Can you be a little bit more specific, and can you give us some, support for that position, either in the form of an explanation or maybe something in writing, something else. So there's a way to do it that doesn't sound like you're, taking a position as opposed to, and cross-examination to me is somebody's shot to try to make the person you're asking questions to, get confused, fold, embarrass them, whatever. That's what we do in cross-examination in a courtroom, is we're trying to, lead a witness into the position we think we want to lead them to, and make them, feel as though they weren't truthful or whatever. That's cross-examination. That we don't do.
Peter, Sandy Redden, I have a question on that. So, not an expert, but if you have a property owner who challenges facts, like they've never seen photos that they've seen, or they've have never been notified by us, or don't remember this, and you believe they're lying, do you just let it go until your decision, or should you challenge them?
You can challenge them by asking them, are you 100% certain, you're telling us that, and that's your testimony. You're telling us A, B, and C, and that's your testimony. Yes, then that's their testimony. You don't have to set the stage for making a determination later that they lied. If you feel later that they were dishonest, I shouldn't say lie, but were less than truthful or whatever, you can make that decision, that determination when you're sitting in your deliberations. So, it's fine to question that in a way that's, I'll say, polite,
Right.
and not, challenging in the way that's, calling them in effect a liar during the public hearing. So So you can save that until you deliberate, and you can mention in deliberations. Just keep in mind, deliberations are in the public as well. And there's a transcript of the deliberations that is part of the record of the case. And I've had situations in other towns where commissioners have said some nasty stuff during the deliberation, and it's come back to bite them. Particularly appellate courts want everybody to be treated with respect and fairly and all that. So you just want to, it's important that everybody feels that they're being treated fairly.
Thank you.
I have a follow-up comment,
Sure.
Kathleen Holland. I liked your suggestion, if it gets a little sticky during the non-cross-examination or the questioning of somebody's information, that perhaps asking for a written reply or a written record of the subject matter, I think actually helps the commission then hopefully get what they need, or at least have it in writing, then to refer to it later. I like that suggestion.
Yeah, just keep in mind that that writing cannot be accepted by the commission after the close of the public hearing.
Right.
So if it's the last night of a public hearing, you can't ask for someone to give you something in writing because it can't be accepted.
Okay.
The only thing that you can accept after the close of a public hearing is if, for example, you have a question about something that, a town engineer or Kathleen can answer for you that's technical in nature, not something that's going to give you new evidence, but something that, you might say to Kathleen, they use this term. I don't know what it means. What does it mean? And she can do that. Or sometimes you have a legal question and you can ask, one of us, Ira or me or whoever, a legal question after the close of a public hearing, as long as you're not getting new information. So now the role of experts, again, as I said before, experts give you substantial evidence. Experts give you the basis for your decision ultimately. And it's up to this commission to determine whether or not, what experts you find to be more credible, what evidence you find to be, more likely true. You're judging those experts in terms of whether or not you think they're credible. And you will, make a decision based on that. And as long as that decision is based, you can't, if you only had one expert come before you and he was the applicant's expert, he was the only person who spoke. Maybe a bunch of neighbors were there and opposing it and they spoke, but the only person who spoke in terms of expert testimony was the applicant's expert. Then a court's going to say you have no substantial evidence to disagree with the applicant because there's none in the record. You can't use your own judgment in a case like that to eliminate or ignore the expert testimony that was given by the applicant if it's the only expert testimony in the record. If there's contradictory expert testimony, then you're free to decide which expert testimony you think is more likely to be that you want to rely on in your decision. But in the absence of any contrary expert evidence, if you only got one side giving expert evidence, you almost have to go with that because that's substantial evidence. There wouldn't be any substantial evidence to support a denial in that case. So, and that's one of the reasons you often hire peer reviewers. You often get, someone to review to make sure that there's contrary evidence in the record, because not all opponents, not all people who show up, even if they have a lawyer, and by the way, lawyers do not give expert testimony. We are not experts in wetlands matters. So anything a lawyer says to you is not substantial evidence. He might be telling you what the law is, or it might be, he might not be wrong about that, but it's not substantial evidence in the sense of whether it's something to consider. Is there an adverse impact to the wetland, or what is the effect on the wetland? Lawyers are lay people when it comes to that. So, but sometimes you'll have neighbors who don't hire an expert Maybe they don't think it's necessary, but for whatever reason, they don't. And the commission has some concerns. You should hire a peer reviewer to take a look at the applicant's expert testimony to see if that peer reviewer agrees. Because that peer reviewer's opinion is going to also be substantial evidence because you're going to hire an expert. And that way you have some decision-making, ability. But in the absence of contrary expert testimony, you're kind of stuck because that's the only substantial evidence in the record. Now, the next question, I'm not sure what the complex application review fee is, but the statute allows you to hire a peer reviewer at the applicant's expense. So whatever fees you have collected, they don't necessarily include expert testimony if you want a peer reviewer. That's separate, and you can require an applicant to pay for a peer reviewer if you think one is necessary. That's only going to be in the public hearing context. So it's never going to happen. If you determine there's no adverse impact, you're not going to have an expert. You're not going to hire a peer reviewer. But if it's a matter that is complicated and there may be an adverse impact, and you feel you need an expert to review the applicant's reports, then you can do that and charge the applicant for that.
Beth Sanford here. I want to make sure I understood what you just said. So we can choose to hire a peer reviewer in the case where there's one scenario is the case where there's an intervener who has not hired experts to justify their intervention. Or I know in cases where we've had our own peer review, so there were 3 sets of experts that we had to list.
That's what we're talking about. The peer review, that's the peer reviewer who gets paid by the applicant pays that individual. That's the third expert when you have a applicant and if you have opposition that's provided an expert as well. You have the ability, you always have the ability in a public hearing to say, we want to get a peer review of these reports. That's what that is.
But you also said, Peter, that we could hire a peer review if the intervener does not have experts because we have some concerns about the application and we want to get another point of view.
Yes, you can. Yes, it doesn't have to be a third, it doesn't have like arbitration. It doesn't have to be the third expert. You can hire a peer reviewer if you think it's necessary, whether there's an opposition peer reviewer or an intervener expert, an opposition expert. You can hire a peer reviewer if you feel it's in the best interest to have someone take a look at the data being provided to you by the applicant.
Okay, so just so that I make sure I got that, so you don't even have to have an intervention to hire a peer review.
No.
And in every case, is the applicant paying for the peer review?
Yep.
Oh, I had no idea about that.
Yeah.
Thank you. Good to know.
Some applicants, as Kathleen will tell you, squawk about it, but that's what the statute provides, and that's what happens. They pay for it.
Taxes.
You want to just turn your mic off?
Okay, next thing on the agenda is ex parte communications and how to handle it if approached or contacted unexpectedly. Ex parte obviously means outside of the context of a meeting, a public meeting. Well, obviously, any conversation that any of you have with respect to a pending application needs to take place only in the context of the public hearing. And that means don't talk among yourselves during a public hearing while a public hearing is going on. Everything you do with respect to an application is done in public. so there's no possibility of any, backroom stuff or anybody kind of getting together and saying, hey, I'll vote yes on this one if you vote no on that one. Not that you would do that. I'm just, but everything needs to be done in public. If somebody approaches you and starts talking about a pending application, you just have to hold your hand up and say, stop, we can't have this conversation. There's a pending application. I'm not having this conversation. Come to the meeting if you want to express your views. But you have to make sure you tell that person that if they start talking about it, that you just can't do that and you walk away. Because first of all, the court is going to review the record of, which is what takes place in public. The record is all the exhibits that get put in, all the testimony, the transcripts, all that stuff constitutes the record, the application, the notice, that's all in the record of an administrative hearing. And so if you're making a decision based on something you heard outside of the public meeting, it's not going to be supported by something in the record in all likelihood. So ex parte communications at any level are to be avoided at all costs. So, and that leads nicely into the review conduct for public site visit matter. And that is public site visits. Remember, public site visits are not recorded. So there shouldn't be any discussion in a public site. If you're visiting a site, other than, what's that, or where does your property end? You can get directive kind of information at a public site visit, but beyond that, it's for observation. And remember, and you know this, if there's a quorum of you present, then it has to be legally noticed as a public meeting. You can during the public hearing, if you haven't had a site visit yet, you can announce at the public hearing, there's going to be a site visit next Tuesday at 10 o'clock. You're continuing the public hearing, in effect to that date, but since it's not recorded, without the ability for anybody to make comments. But it's better to notice. It doesn't have to be noticed in the paper. It just has to go on the website within 24 hours of the site visit, if there's going to be a quorum. If you're visiting a site individually, or maybe two at a time, it's not a quorum. You don't have to post notice of it. But again, whether it's a quorum or not a quorum, things should not be discussed during the site visit other than getting, directions and being able to orient yourself on somebody's, property. And finally, no site visits without permission of the applicant. The applicant has to agree to a site visit. Otherwise, you're trespassing. So you don't want to get caught in that situation but an applicant is going to typically agree to a site visit, because if the commission thinks a site visit's necessary and the applicant says no, well, you've given that's grounds ultimately, to support a denial, possibly because you needed a site visit and the applicant said, no, I don't want anybody on my property. And by the way, when there's a quorum present, that means that anybody, including a neighbor, maybe this applicant's not getting along with her next door neighbor and doesn't want them on his property. Well, either they are allowed on or nobody's allowed on if there's a quorum, because that's a public meeting. So, and I've seen that a lot of times where the neighbors are not happy with each other and they'll say, yeah, I'll agree to have you guys come on, but she can't come on. Well, then nobody can come on. And that's in effect, that's going to hurt the applicant. They have to kind of suck it up and say, okay, yeah, anybody who wants to come on, if there's a quorum, if you hold a site visit with more than with a quorum present, then anybody can be there. No, they can't speak either though. So.
Pete, just to let you know, we got 15 more minutes. So
Oh, wow. Time flies.
it does, doesn't it? So we got probably 4 more that we can try and get through, and then another time we could perhaps review recent judicial decisions. So
Okay, yeah,
go for it. Thank you.
okay, yeah, thank you. Okay, feasible and prudent alternatives. That's all, confuses a lot of commissions. Feasible and prudent alternative. Feasible means it can be done. You know, there's a way to do it. There's an engineering, method where something can be done. Prudent means that it is to some extent that's a cost analysis in a way, that how much it will cost or what has to be done compared to the public benefit that it provides. So whenever you have something that during the course of the public hearing you think may have an adverse impact or is likely to have an adverse impact, you can suggest to the applicant, is there a feasible and prudent alternative? Can you move that bridge over there? Can you make that, bridge out of a different kind of material? Can, whatever that would lessen the impact, the adverse impact. And some applicants will say, no, it's not feasible or it's not prudent. In which case, you're going to make a decision whether you think that's correct, and then you'll vote on the application itself. So feasible and prudent alternatives, as I've said, if they exist, then they have to be put in place and they lessen the impact, and the feasible and prudent alternative is still has is something you can approve. I mean, just because it's a feasible and prudent alternative doesn't mean you would necessarily approve it. It means that it has less of an impact than what was applied for. But even with a feasible and prudent alternative, you got to be able to show that the impact is not so severe as to outweigh the property owner's right to develop their property. So, and just because something has an adverse impact doesn't automatically mean you got to deny it. It means you take a look at that, and again, you weigh it, and and look at feasible and prudent alternatives, or maybe look at some mitigation. If the activity is destroying some wetlands, but the applicant is willing to create wetlands in a different location on his property, that's something you can take a look at. So it's not every adverse impact to wetlands deserves a denial. But in order to be denied, there has to be an adverse impact. You can't deny an application that does not have an adverse impact. But even if it does, you might still approve it or approve it with conditions if you feel those are appropriate. Well, we already talked a little bit about the statutory time limits for public hearings, because amending the regulations and holding a public hearing, have the same time limitations. Without a public hearing, as I said, you have 65 days. With a public hearing, you have the 65, 35, 35. And you have the same provisions for amending your regulations, which, and that includes, by the way, amending the wetland map. If you ever, you have an official wetland map someplace, but typically those are outdated or they're not accurate because they were done through aerials. The most accurate wetland mapping is done by the applicant at the time they apply, because they have to flag their wetlands. They have to have a soil scientist come out there. And even if those wetlands don't show up on a wetland map, the town's wetland map, they're still wetlands. And recusing. Recusal is an individual decision. Nobody can make somebody recuse themselves. Town attorney's office can't do it. Even a majority of the commission can't do it. It's an individual decision. You recuse yourself if you have a conflict of interest typically. And a conflict of interest means you either have a personal or financial interest in the application, the applicant, or the applicant's expert or attorney. So if the applicant comes in with an attorney who is your attorney, you should consider recusing yourself. You ought to recuse yourself. But again, it's your decision. And if you don't recuse yourself in a situation where you should have, it jeopardizes the commission's decision. So that's why it's important to do that if, if that situation ever arises. But in a town like New Canaan, you know a lot of people. Just because you know somebody, maybe casually, doesn't mean you're necessarily conflicted. But you have to look at that on a case-by-case basis and ask yourself, is this person a close enough friend of mine that I really want to, in my heart of hearts, I know I want to help them out. I want to give them an approval if I can. That's conflict because you need to be as subjective as you can. And so a personal relationship, or maybe you have invested in something where an applicant did a project years ago or unrelated to this application. But again, you have to look at that. I mean, there's a point where it's so remote that it's not a conflict in all likelihood, but it's strictly a case-by-case analysis that you have to undertake to determine if you need to recuse yourself. And if you recuse yourself, by the way, you ought to leave the room, not just go sit in the audience, because people can unconsciously make faces subconsciously, not unconsciously, you'd be asleep, but subconsciously, make faces or do something or nod their head or whatever that catches the eye of a commissioner. So when you recuse yourself, you ought to leave the room. If you're on Zoom, you ought to, get your picture off and mute yourself so nobody can see you while that's happening. And an alternate can either be put in your place, or as long as you have enough people, you can proceed with a quorum. So, but conflicts, I've had situations where people have just refused to think they have a conflict when it's apparent on its face. And if they decide to sit, they sit. Nothing anybody can really do about that except the judge down the road when he says that person shouldn't have been on the commission. That was that whole public hearing was tainted because someone with a conflict was there. So that's the risk. Well, we have 5 minutes left. I can tell you there haven't been a lot of legislative changes. The recent judicial decisions, primarily the wetland law was really established back about with the Supreme Court and the Appellate Court about 10 to 15 years ago. There's a few cases one's called Riverbend case. I can get you, it'd probably be easier rather than talk about those to maybe get you a written summary of some of those. But, some of those stand for the proposition of, and this is important, actually. This is one of the things that these more recent cases stand for that you have to be aware of. When you're determining that an activity is going to have an adverse impact on a wetland, you can't just make a decision. Let's say someone says, there's going to be, from this activity, there's going to be a lot of dirt that's going to find its way into a wetland. That's not there now. And you say, okay, well, we're denying the application because there's dirt that's going to go in the wetland. That's not going to hold up, because what's the effect of that? What's the quantifiable effect of that dirt going into the wetland? Some expert has to tell you Not just that dirt's going to go in there or PCPs or whatever, are going to find their way to a wetland or to a water course. They have to identify what the adverse impact of that dirt is going to be. It's not intuitive. You can't just say, well, isn't dirt adverse to a wetland? Well, you'd think so, but you need to have an expert telling you that. So the damage, the adverse impact needs to be quantified and specified if you're going to rely on that to make a decision. So, and it's one of the things that is hard to do sometimes because you hear the activity and you hear what's going to happen and you feel like, well, that's enough, but it's not enough. And as commissioners, you can ask that question to an expert. Okay, so this dirt is going to go into the wetland. What does that mean? Does that mean the wetland's going to, what's going to happen to the wetland? Is it going to be less effective? Is it not going to, are the soils going to change? Are the plants, going to change? What's going to happen as a result of that? And so you need to kind of, tie that bow and get it, all that information into the record to support your decision. So I don't know if anybody has any questions. We have, looks like 3 minutes. I think as Kathleen knows, I am doing a training session tonight for the Wilton ZBA as well. So it's training night. But anyway.
Well, Pete, want to thank you very much indeed for very helpful, insightful training session this evening. I don't know if anybody has any final questions for Pete. If not, would like to thank you and ask whether there was a commission member who would like to propose that we adjourn the special meeting.
And by the way, Angela, if anybody thinks of a question later,
right,
what they should do is submit it to you in writing, and then you can submit it to me. It's better if things go through the chair. That way, maybe the same question's not asked by multiple people and whatever. So if somebody thinks of a question later, send it to Angela. She'll send it to me, and I'll be happy to try to answer that.
Well, thank you very much.
I would like to propose. I would like to propose that we adjourn the special meeting.
Very good.
Second.
Thank you, Mr. Ramirez. All those in favor, please raise your hand and say aye.
Aye.
Unanimously accepted. The special meeting is adjourned. So now let us turn to the regular. Phil, who's going to be joining us?
Oh,
just texted that he's going to Zoom in. Good evening. This is Angela Jameson, Chair of the Inland Wetlands Commission, calling to order the regular meeting of the New Canaan Inland Wetlands Commission on Monday, September the 15th at 7:01 p.m. Please could the secretary call the roll?
Angela Jameson.
Present.
Sandy Redden, I'm here. Beth Brunali.
Present.
Beth Sanford.
Present.
Daniel Stepanek.
Here.
Philip Williams. Absent. Priscilla Wokley.
Present.
Donna Mastronardi.
Absent.
Katie Owsley.
Absent.
Adam Ramirez.
Present.
Very good. So, Mr. Ramirez, would you please be seated for Mr. Williams?
Yes, thank you.
Thank you. So first item for us to consider is the agenda. If anyone has any questions or issues, please raise them now. Otherwise, could I please hear a motion to approve the agenda? Ms. Woike moved approval, seconded by Ms. Sanford. All those in favor, please raise your hand and say aye.
Aye.
Aye. So the agenda is approved unanimously. Next item is approval of the minutes of the regular meeting of July 21st, 2025. You've all received copies of those draft minutes. Anybody have any comments or edits? If not, could I please hear a motion to approve them?
I move to approve.
Mr. Stepanek moves to approve.
I second.
Mr. Ramirez seconds the motion. All those in favor, please raise your hand and say aye.
Aye.
Any abstentions? Or
I will abstain. I don't believe I was present.
Ms. Brinali abstains. Thank you very much for putting up your hand on that. So the minutes are approved, the minutes of the regular meeting of July 21st. So now we will open the regular meeting and we will receive applications, and if complete, they will be scheduled for our October meeting on October the 20th. Application IW-25-41, 70 Hillcross Road. Jeffrey and Shelley Ecclestein, trustees. The application is to replace existing 12-inch CMP driveway culvert, replace the footing drain and leader pipes, perform related landscaping work. So we should schedule a site visit, and the date we have in mind is October the 15th, just before the next regular meeting. Could you please look at?
Is it I'm a year ahead.
Year ahead.
I was looking at the calendar, yes.
Wednesday,
You're correct.
Wednesday, October
October
15th. Who will be available for that?
I'll be available.
Adam, Mr. Ramirez, Mr. Stepanek, Miss Sanford,
Yes.
Miss Wojcicki.
Uh-huh.
Okay, Miss Brunali.
I believe so, but
Okay, very good. Mr. Redden, has his hand there. He's ready.
Yep.
As am I, and I don't think we have anybody else, any other commission members on Zoom.
Now, hold on. Oh, hold on. But Phil is joining the meeting. so
Okay.
We'll get him involved there. So that's-
Good evening, Mr. Williams. Well, we have a quorum anyway. Mr. Williams? I think you're on mute.
Unmuted, so
Yeah.
We do have a quorum.
How about now? Can you hear me now?
Yes, loud and clear, and we can see you very clearly too. Thank you. So we're just discussing a site visit for October the 15th. It's a Wednesday. Is that a date that you'd be able to make?
As far as I know, yes.
Terrific.
And will that be at 7 or 8 o'clock in the morning?
Well, that is
7:30? Is it usually what we're doing? Is that what we're doing?
so.
Are we doing 7?
Have we done 7 or 7:30? Okay, 7:30.
At 7, you're not gonna,
I'm sorry.
You won't be
I think
right.
7:30.
Okay.
we haven't done 7 yet.
Yeah, no, we haven't done 7 yet.
Well, we have a few years ago, but okay. How-
Adam said no. He
How
said
would
come in.
7:30 be to make
That
it
works-
easier for our folks that have
That works for
day
me.
jobs? Okay, okay, 7:30.
And Don is joining the meeting,
Very good.
so you might want to ask him.
Mr. Mastronardi?
Hello,
believe you
everybody.
joined us. Hello there, how are you?
Good, how are you?
Good. So we're just discussing the next site visit. We've come up with Wednesday, October the 15th at 7:30 a.m. Does that work for you?
Yes, October is pretty open.
Good, great, very good. And Miss Holland will send us a calendar invitation and then also remind us nearer the time. Very good. So let's move on to the agent's report. 1, 2, 3, 4, 5. permits that were granted. Anything you'd like to comment on, Director Holland?
So, Kathleen Holland for the record, over the August month, a decent amount of new applications came in with a variety of activities, some of which have started in the process, obtaining their permits and going through all the reviews with all of the particular departments. Wetland permits administrative were able to be issued for 310 Grinley Road. 54 Rocky Brook Road has not actually started yet. 100 Toby's also probably not started just yet. 317 Park Street has actually started and already completed that activity. And we've already actually closed that permit. 311 South Bald Hill is just got their approval recently, and that will be a renovation of an existing structure at that location and some pools activity. So fairly decent amount of construction activities still being undertaken.
Sounds like you've been busy. We know that. Does anybody have any questions on these administrative actions? No. So the next item on the agenda is the schedule of meetings for 2026. We're actually going to table that tonight. It's going to be tweaked just a little bit, and we will discuss it at our October meeting. So any other business from any commission members? If not, could I hear a motion to adjourn the meeting, please?
I make a motion to adjourn the meeting.
Thank you, Mr. Ramirez. Ms. Sanford,
Second that.
second that. All those in favor, please raise your hand. Aye.
Aye.
Motion carried. Thank you very much, everybody, and see you on October 15th and then October 20th.
Voila.
Thank you.
Thank you.
Excellent. Thank you, everybody.